All right. Um, well, for those who are either going to join us today later, or for those who are going to be watching with us later on the YouTube channel, we're glad you're here. We've got a really awesome lineup. So we have, today the whole topic is going to be about elder law, estate planning, and then even how to navigate kind of Medi-Cal planning as well in regard to having an ALS diagnosis. So we have two awesome speakers. We're really thankful for them to be here today. We've got Stacy Denherder. She's an attorney at Denherder and Associates. So there's Stacy. And then we've also got Maya Pinchman. So she's also an attorney at Ratner and Pinchman. So I kind of just wanted to start with our speakers just to ask, how you might have been connected to ALS, or whether personally or in your career.
Well, mine is unfortunately personally, because one of my best friend's husbands got ALS, and that's when it became really real for me and my family. And since then, I've been connected with the ALS group here in San Diego. And unfortunately, I have another very good friend that also has ALS. And it seems that more and more people I'm associated with have ALS. And it's that's quite a struggle, and I'm happy to be a resource. Our firm is an estate planning law firm, so we've helped some of the ALS families in making sure they have their main documents in place so that transitions can happen seamlessly without a legal crisis and having to go get conservatorship or something like that. So that's kind of what I'll be talking about today, but my specialty is not Medi-Cal planning or elder law. And that's when I asked Maya if she would join me, because we referred to her firm. They have a specialty in that arena, and I'll let her tell you about that. But my firm doesn't typically do that kind of planning. And so we like to use somebody who's an expert in what they do. And we're great at what we do, but that's something that she's great at. So with that, I'll introduce you to Maya Pinchman.
Thank you so much. And so, yeah, our connection to ALS is mainly the clients that we've been helping. We do have a number of clients that have turned to us needing help with care and trying to make sure that they don't run out of funds, because unfortunately, oftentimes ALS hits at many different ages. And so many people need to ensure that they protect as much of their assets as possible while still being able to afford the care of the spouse or child or parent who has been diagnosed. So our specialty is helping qualify for Medi-Cal, helping preserve assets while utilizing the estate planning documents that are in place by attorneys like Stacy. And that's mainly our connection.
Yeah, it's so important. That's something that families are asking me constantly, is just thinking of, even financially, like, what does that look like to make the most of our assets here, have the coverage we need, and being able to think for their future in that way. And so and it can be very stressful. And so it's what you guys do is so important, just to almost be a guide with that, and to be able to kind of just provide us with more information. So yeah, that's awesome.
Well, happy to be here. So with that, should I just launch right on in?
Yeah, go for it, Stacy. Launch in.
And this is my first time also sharing my screen. So now I'm admitting to you my limitations in the technical arena. So let's see how this works, because I do have a little presentation for you, but we'll see if I can make it work for us. Hopefully. All right, so that's just a picture of our law firm. We'll go past that. And I'm just going to jump right in about estate planning and what estate planning is, so that you understand why we recommend what we recommend. Let me see if I can make it work now. Bear with me. Oh, that's how you do it. Hey, look at that.
Nice.
It's always so amazed when it works. So you know, our whole philosophy is that when you do estate planning, it's not only for your own benefit, but it's because you love somebody. If you didn't love anyone, you wouldn't do any planning because you wouldn't care. But you do planning because you care, and you take care of the people that you love. You make sure they can take care of you if you have a situation where you can't take care of yourself. And you want to be a good steward of the resources that you've worked hard for. So that's what estate planning is all about. There are basically two types of estate planning. One is planning for incapacity. So what happens if you're alive but incapacitated? And the other is planning for what happens when you're gone. So those two things encompass estate planning. When we're planning for incapacity, we're talking about what happens from a financial perspective and also what happens from a healthcare perspective if you can't make your own medical decisions for yourself. Planning for when you're gone, it has all the implications of who raises your children if you have minor children, who inherits from you and how do they inherit from you. Do you have beneficiaries with special needs, or do you have beneficiaries who have substance abuse issues or gambling addictions or all kinds of things that could come up, and we need to plan to make sure that what you give them doesn't destroy them, but instead helps them in their lives. Are you a blended family where we've got his kids, her kids, our kids? There's all kinds of things that come along with planning for what happens when you're gone. So when we talk about an estate, some people think they don't have an estate, but everyone has an estate. I mean, you have something. You may have a guitar, and that's your estate. But for, you know, a family where you have had resources, it would include your home or any other real estate, your savings and investment accounts, your retirement plans, your personal belongings, your businesses, life insurance, everything. I know at the time that you have been diagnosed with ALS, it's going to be too late to get life insurance, but there may be a well spouse that doesn't have sufficient coverage, and I encourage you to get that coverage because the sooner you get it, the better. And if you need the life insurance. So that's if you have young beneficiaries that need to be raised. If you have a situation where you want to create more of an estate, that's where you would consider life insurance. And I'm not going to jump into that too much. There's a lot that goes into considering the types of life insurance and how to get life insurance, but all of it is part of your estate. So basically there are three types of estate planning. First, and by far the most prevalent, is none. The statistics say that about 70% of the US population has no estate plan at all. They've done nothing. And that's called dying intestate without an estate plan. And that is when your estate will go through probate. And I'll talk about that in just a minute. There's also the use of a will. And we'll talk about how a will works and what it can do for you and what it does not do for you. And then we'll talk about the use of a trust. So those are basically the foundational documents for an estate plan. So what happens if you do nothing? If you do nothing, the state of California has determined exactly how your estate will be distributed. And basically, if you're married and everything is community property, it would all go to your spouse. If you have things that are separate property and you're married, if you die, a portion would go to your spouse and a portion to your kids. So that may or may not be problematic depending on your family dynamic. Or you may have a situation like what I had with a client years ago who she had 2 children from a prior relationship, and she and her spouse divorced, and those children sided with their father and chose never to speak to her. And she remarried and had another family and has 2 children from that marriage, and they're her world and her family. And I got a call from one of the daughters saying that her mom had had a heart attack, and in the midst of the heart attack had handed her my business card and said, call Stacy. Well, she had made several appointments with me and canceled every single one of them. So she had done nothing. The daughter was calling saying she was following the ambulance to the hospital and could I help with all of this? So I met them at the hospital, and the mom was able to talk to me as she was going into emergency. And she said, you know, I have these 2 daughters that I want to get everything, and I don't want my other 2 children to get anything. And at that moment, I knew exactly what she wanted. She was going right into the emergency room. There was nothing I could do at that moment, but I came back to the office, drafted up documents for her to sign. She had emergency surgery. She came through that emergency surgery. I got to the hospital, got her everything to sign, and she told me she didn't want to sign it yet because she was afraid if she did, she would die. And you know, Maya, you've probably heard things like that too, where clients are scared to sign an estate plan because it makes it feel like they're giving up or something. And nothing could be further from the truth. That signing of the document, I've never had a client keel over after signing their documents. But she had me leave it there by her bedside and she didn't sign it and she died that night. So the result was all 4 children inherited from her equally, even though there were 2 that she hadn't had a relationship with in over 40 years. And that isn't what she wanted. So if you do nothing, you can have distribution problems. You can have additional fees and taxes that are completely avoidable, and your estate would go through probate. So what is probate? That's a court process of transferring your assets out of your individual name into the name of your heirs. So for example, if I want to buy your home from you and you and your spouse are on title to your house, both of you have to sign off on the deed in order for me to take title. If, on the other hand, I'm your daughter and you leave a will that says when we die, we give our home to our daughter, well, you 2 could pass away. I could pick up your will, show everyone I want I'm supposed to get your house, but title's still in your name. And there's no way to get it from your name into my name except through a court proceeding because you're dead. That's probate. In California, that process takes between 9 months and 2 years to complete. So during that time, the assets are typically tied up. Probate fees are set by law. You can estimate them at about 4% of the gross value. So if you think about that, if you have a home worth $600,000 and you have a mortgage of $400,000, so there's only $200,000 equity, you are still charged probate fees on that full $600,000. And you can estimate that fee, like I said, at about 4%. So $24,000 just to transfer your home out of your name to whomever it is you want to inherit. So that's why it's a great thing to avoid. It also offers no privacy. Anything that happens in the probate court is open for public scrutiny. So what happens if you do a will? Will you avoid probate? No, you will not. A will always goes through probate, but you can control the distribution of your estate. So that client of mine, if she would have signed just a simple piece of paper to say, when I die, I leave everything to these 2 children and I disinherit the other 2, that would have been sufficient for her 2 that she wanted to inherit from her. So you can control who gets what and how. You can name an executor, which is the person who manages your estate. If you have minor children, you can name a guardian for your minor children. But as I mentioned, a will always goes through probate. Now, it might not go through probate. I'll back up. It might not go through probate on a first death if you're married, because often when you're married, the way you hold your assets is in joint tenancy with right of survivorship or community property with right of survivorship. So that means if one of you dies, the other one gets everything. There's no problem legally. There's no tax. There's no probate. The problem comes in on the second death or if you both die together. So that's when we go through the probate process. So some of the disadvantages to having just a will, well, it's effective only when you die. It does nothing for you if you're alive but incapacitated. The estate tax issue isn't such a big deal these days because now you can leave over 11 million to your heirs without estate tax, so we don't have to worry about that. But a will always goes through probate. So I just mentioned the ownership of your assets, and the way you own your assets controls things. So if you leave a will and you say, I give my house to my best friend, and you're single and you name your best friend in your will, but your house is owned in joint tenancy with your sister, then your sister wins. The way the title is on the asset trumps whatever you write inside your will. So the way you have your ownership, it's important that all of that be coordinated, and we make sure that your estate plan coordinates everything so that something doesn't happen inadvertently that you didn't intend to happen. Sometimes joint tenancy can be a poor alternative because you might think, well, then I'll just add all the kids on the house. Well, if you add all your kids onto your house with you, it's true if you die, your kids would inherit your house. Um, but what happens is then, let's say you don't die and you want to sell your home and you've already added your kids on title. They have to agree to sell. If one of your kids is sued and there's a judgment against them, your home can be subject to your kid's judgment. What if one of your kids wants to move in with you and they want to bring their significant other who you don't care for, and this is your house? Well, now that they're on title, they're an owner. They have equal rights to you. So there's all kinds of issues of adding somebody as a joint tenant that can really create problems. It also can increase capital gains tax issues that could otherwise have been avoided. It triggers a gift tax when you add people on title. It can trigger a property tax reassessment. So my point to all of this is to say that it's a good idea to get legal advice. Even though attorneys cost some money, it's best for you to get legal advice so you know what you're doing and you do it right. Because if you do it wrong, fixing it on the back end costs hundreds of thousands of dollars sometimes, depending on what was done, where you could have spent $1,000 and done it right up front. So it's just a cautionary tale to be careful how you do things if you're one of those do-it-yourself type people. So let's talk quickly about incapacity. So incapacity are the issues of who can make your medical decisions if you can't make them for yourself, and who can make your financial decisions if you can't make those for yourself. The way we take care of those are through powers of attorney, and they're typically called durable powers of attorney. These are documents that typically go into effect if you're alive but incapacitated, and it's where you give somebody the power to step into your shoes financially to make your financial decisions, and somebody the power to make medical decisions for you. A medical advanced healthcare directive gives somebody the power to determine life and death issues, when to stop life-sustaining treatment or when to continue, whether you want to be buried or cremated, whether you want to donate organs. All of that is covered in a medical advanced healthcare directive. The financial durable power of attorney gives somebody the power to make all your financial decisions for you. These two documents are crucial documents. Everyone should have them. Finally, there's a trust, and I'm going to just hit this quickly, but a trust is kind of a cure-all to the probate issue, and it covers almost all of the things I've been discussing up till now. A trust is very similar to a will. It says who you are, who your heirs are, under what circumstances everyone inherits. What's different is you transfer everything you own into the name of your trust. So instead of you owning your home as an individual, your trust would own your home. So for example, I have a trust, it's called the Denherder Family Trust, and my husband and I are the owners of the trust. We're also the managers, called the trustees, and we're also the beneficiaries. We can use the assets of our trust, we can change our trust. Everything in the trust is 100% for our use and during our lifetime. But if we die or become incapacitated, we've named a successor trustee to manage everything. And we've spelled out who our beneficiaries are and under what circumstances they inherit. So the parties in a trust, there's the trustor. So like in my situation, my husband and I are the trustors. We are the people who create the trust. We put our assets into the trust. We are the trustee to manage everything. And then we use the assets from the trust. Once we die, our successor trustee steps in and our beneficiaries step in. So the first advantage to having a trust is that it completely avoids probate. And the reason it does that is that once you transfer your home into the name of your trust, back to my original example, if your trust says your home goes to your best friend, well, you can die. Your best friend can tell your trustee, hey, so-and-so's died. The trustee reads the trust and says, oh, well, the home goes to best friend. Now the trustee has authority to sign off on the deed and hand best friend a home or sell it and distribute the proceeds. So assets are distributed much more quickly than they are through a probate. There are some time delays, so this is a little misleading on my slide. I need to fix that. But that's just some of the notifications required under California law. And a trust maintains privacy. So the only people who know who all gets what are the people named in the document or your heirs. A trust also can cover the issue of incapacity, because a trust automatically says if you're ever alive but incapacitated, you give your successor trustee the ability to handle all the assets of the trust. You still need somebody to have financial power of attorney, because there are some assets that can't be owned by a trust. So those two documents go hand in hand. You can cover all the what ifs, who all you want to inherit, under what circumstances you want them to inherit. You can take into account your special beneficiaries, people that need to be protected from themselves. If you have that blended family situation, you can cover all of that. It's very comprehensive and in much more depth than you find in a typical will. You can keep your family from hating each other. I do an entire workshop on how to keep your family from hating each other when you're gone. I'll make this PowerPoint presentation, I think will be available to you, so you can kind of go back through this slowly. But these are some of the hot topics that we see where people make mistakes in their estate plans, making one sibling the other sibling's keeper, because you have one golden child and one child who doesn't quite measure up for some reason. There's all kinds of things that can cause the family dynamic to crumble, and you don't want to do that. You want to leave the best legacy you can. You can also include more of your heart in your estate plan. So one thing that we encourage with our clients is that you make this your last love letter to the people you leave behind. So like in my trust, I have a section to my boys about the kind of person we hope they marry and what we think it takes to make a good marriage. We wrote about our faith and how we hope they don't lose their faith because of whatever happened to us. We wrote about our money and how we expect them to use our money. And we just wrote how you rocked our world. We love you, we love you, we love you. We would rather have everything we have burn and you still have a relationship than for this to come between you. That is written right in the midst of my trust. So you can do all kinds of things to make this more of a legacy of love and not just your things. There's ways to talk about estate tax and reduce estate tax. That's a little beyond what we're going to talk about today. Picking a trustee is really important. So go back and review these slides about the duties that a trustee has. This is the person who steps into your life when you become incapacitated. They take over your financial life. They make sure that your bills get paid, figure out what your income is. They decide what assets should be sold or liquidated first before other assets. It's a huge job. So be sure you don't pick somebody who's broke, somebody who's not good with money, somebody who's too busy. So there's all kinds of things in here, and I'm going to flip through this pretty quick because it's too much for you to really, for me to get into right now. But the trustee that you should choose is somebody who's equipped, who's licensed and insured. If you pick a professional trustee who will commit to educating your family on how to manage what they're given. So it's a big job. Basically, in summary, there are 3 crucial documents everyone should have, no matter what your age is. Everyone should have a financial power of attorney, everyone should have an advanced healthcare directive, and everyone should have a will. I'm just going to give you a quick story about that to kind of help you understand why I say what I say. My best friend's son, when he was 18, went off to college, and he was involved in a rollover car accident. And one boy died at the scene, and my best friend's son was brain injured. And she got that call in the middle of the night that every parent dreads, saying your son has been in an accident and he's being life flighted to a hospital in Las Vegas. So she rushed to the hospital in Vegas, and so did his dad. They're divorced. And when they got there, the hospital had him stabilized, but they wanted to do a surgery that was a little bit controversial. And she said yes. And his dad said, I'm not sure. And the hospital said, since neither of you have a healthcare power of attorney, an advanced healthcare directive, and he's an adult, he's 18, which we don't think of our adult children that are 18 as adults, but they are. The hospital said one of you needs a court order. So I helped her get an emergency conservatorship over her son so she could make his medical decisions for her. That cost about $6,000 to get that done. She got conservatorship. She made the decision to have the surgery. He had it. He was in a drug-induced coma for a little over 2 months. And then when he came out of that, he had to learn how to walk again and talk again and feed himself. In the meantime, the boy who fell asleep at the wheel, he had $200,000 of auto insurance. And that insurance basically was going to go to the family of the boy who died. My friend has underinsured motorist coverage. So now you know why that's something that you're always asked if you should buy it. And yes, you should, because if you're ever in an accident and somebody doesn't have enough coverage or there's no coverage, your own insurance will pay. She had 500,000 of underinsured motorist coverage, and he was a policy owner under her also. But the only way you can get that money is you have to sue your insurance company to get it. And the only person who can sue them is the person who was injured, which in this case was the boy who is learning how to walk again and talk again, who has no ability to bring a lawsuit. So if she would have had a financial power of attorney that he had signed when he turned 18, she could have brought that lawsuit on his behalf, but she did not. And when we went to court and got emergency conservatorship, we only got health powers. We didn't get financial conservatorship. So we had to go back to court a second time, $6,000 more later. And here I was a lawyer, and I had never thought about 18-year-olds, about all my clients, young adult children. They all need an estate plan. You need an estate plan. Everyone should have an estate plan. So I bring all that up just because it helps you understand how these documents could be used and why you need them. And then a will just says who gets whatever you have if you're gone. In California, we recognize what's called a holographic will, and it's a will done completely in your own handwriting, dated and signed. So basically that will, you just have to say, I intend for this to be my will. And you write out, I give everything I have, or I give my guitar to this person and my car to this person. I give whatever you want to whomever, and sign it and date it. That's a valid will. Those are the crucial documents. If you're going to have a complete estate plan, because you have more assets, and generally it's if you have $160,000 or more in assets, or if you own real estate, or even if you have young children and you have life insurance, you should have a trust as the foundation of your estate plan, along with a financial power of attorney, a healthcare directive, and you still have a will, even when you have a trust. But the type of will that goes with a trust is called a pour over will. It's just a backup safety net will that says, I meant to transfer everything I own into my trust, but if I forgot anything, whatever I forgot should pour over to that trust. So that kind of gives you a flavor of why we recommend what we recommend. When I talk about those probate fees being 4% of the gross value of your assets, it's not the state of California who gets those fees, it's we attorneys. So we would make a lot more money on probate, but it's our heart to educate you to do something that's better for you and your family by doing comprehensive estate planning to avoid those kinds of fees. There's a slide in here, how you find the right attorney. I think you should reach out to somebody who only practices in the arena that you are looking for. You can attend typically a free consultation. Make sure that you feel that you can communicate with them, but don't be cheap. Sometimes when you go with the cheap, you're doing a glorified do-it-yourself. And sometimes it's a lot better to have somebody walking you through the whole process. So that's basically my portion of the presentation. If anybody is interested in, I have a slide deck on writing your own will. And if that's something that you want to do, I'd be happy to provide that to you. So you'd have to just get the information for me off of this PowerPoint. Oh, no, you wouldn't, because it's right here. I forgot I put it in here. And I don't know, Lindsay, if you'd like me to go through this so that it is on your YouTube channel and people can kind of go through this. That's how it would work, right?
Yeah, I was going to say either like, because sometimes I could even pass on that information. If you have it in a slide, I can pass it on just depending on.
So let's do that. And this is enough for now. I will go ahead and go to the end of this so that you have my contact information on this slide, but you can always get it from the ALS Association. Oh, it's right here at the end somewhere. Huh.
Yeah, but that sounds like an amazing resource too. So
there we go. And so I know there's a lot more to this when it comes to now being concerned about, I have ALS. If I have ALS and I'm anticipating there's going to be a lot of expenses and I'm scared for what my future holds. And if I'm married, is my spouse going to have to spend down all of the assets and be destitute or that sort of thing? So this is where I invited Maya to step in, and she can maybe give us a little more of the presentation from that perspective.
Thank you so much.
I was going to say thank you so much, Stacy, and Maya. Before we jump in, I was just going to let you know, for anyone who's joined us, we'll have some time at the end for some Q&A. And so we'll kind of open that up too and kind of go from there. But yeah, thanks, Stacy.
Perfect. Thank you, Stacy, for laying such a solid foundation on where I will pick up. So by the time the client comes to us, usually they've been diagnosed with ALS or another illness of some sorts. And like Stacy said, expecting expenses to absorb a significant portion of their estate, and they're trying to see what can be done to preserve as much as possible for the well spouse or for the other family members who need those funds to live off of as well, and provide care for the individual that needs care. The first thing we often look at is the estate plan. Luckily, oftentimes with ALS, mental capacity is not impacted. And so a person often still has the wherewithal to be able to communicate and understand what's being done. So if an estate plan has not been set up, but beforehand, that's the first step, is to set up an estate plan for the family to make sure there is a power of attorney that authorizes Medi-Cal planning and a trust and a will and a healthcare directive, all the documents that Stacy just thoroughly covered. What we look for within those documents is, do the documents allow for assets to be transferred out of the names of the owners of those assets to be able to preserve those assets? So if we're looking to qualify for Medi-Cal, and what Medi-Cal can provide is coverage of caregivers at home, or if in the future at some point the patient needs to go into a skilled nursing facility, Medi-Cal would cover the cost of that bill, which can run 8 to 10 grand a month. So it can deplete your assets pretty significantly. Obviously, most people's wishes are to stay at home as long as possible. And that's where in-home support services comes in, where oftentimes, they're already paying for caregivers to cover some of the care, and Medi-Cal can help cover a portion of that care. So less out-of-pocket costs. In order to qualify for Medi-Cal, however, there is a limit. When it's a husband and wife, Medi-Cal allows the applicant to have one primary residence, one exempt vehicle, and between the two, $130,000 approximately of countable assets. That does not include retirement accounts. Retirement accounts can be turned into unavailable assets. So we usually aren't worried about retirement accounts, but stocks, savings accounts, checking accounts, life insurance policies that have a cash value, so not term policies, but whole life insurance policies, all of that is countable. And so when an individual comes to us, or a couple, we first look at, what does their estate plan allow? What is the extent of their assets? And then we try and figure out, if the estate plan doesn't have provisions that allow for Medi-Cal planning, essentially that says, I authorize my spouse or my agent, whoever is appointed as the agent under those documents, to make gifts of my assets to my beneficiaries without a limit. Great. If those documents don't have those provisions, oftentimes we'll want to add those provisions, because whether that person's mental capacity is strong now doesn't mean their mental capacity will continue to stay strong. And so we want to ensure that the documents in place give the unlimited ability to preserve as many assets as possible, and we're not depending on the patient's capacity to be able to move things around. Not all cases work for Medi-Cal planning. When it's an intact family, let's say a husband, wife with children, that everyone's on the same page, there is no one that's stealing money and misappropriating funds from parents, it's pretty straightforward. Oftentimes we can make gifts to children, the children hold the money, and it's a gift, so the children don't have to use the money for their parents, but everyone is under the understanding the children will help take care of the parents if we're over that $130,000 threshold. If, however, the person doesn't have children or other individuals that they could transfer their assets to, it becomes more complicated, because it's not in all cases does it make sense to make gifts or set up irrevocable trusts, because you don't know if you can trust that individual who you just gave your assets to really use those funds to help supplement your care. So Medi-Cal planning depends on many factors, one of which is the dynamic of the family that we're working with. Are there children with creditor issues, with spouses that are overpowering them, and can you rely on that child to preserve those funds? There are still ways to protect ways by putting them into an irrevocable trust rather than doing outright gifts. But all of that is factored into. So each case is very case by case. The plan that we come up with really depends on so many factors in each scenario. So let's give a scenario. What happens if a husband and wife come in, husband has been diagnosed with ALS, and they already have caregivers that are taking care of the husband, and they have, let's say $500,000 in investment accounts, a house, 2 cars, and some retirement accounts. They have minor children, but they have parents that are still living and helping them out as much as possible. So we look to the estate plan. The estate plan is perfect. It has all of the Medi-Cal planning provisions that we look to. And then we figure out how much over the threshold are we? And then we look at who are the beneficiaries. Is the husband comfortable with gifting everything over the limit to the parents and have the parents hold on to those funds? And then people sometimes ask about Medi-Cal. They've heard of a 30-month look back period. And they go, how can you make gifts? You can't make gifts. There's this look back period and it's going to cause a problem. So in California, the look back period is 30 months. And what Medi-Cal means in this state with the look back period is any transfers done during those 30 months must be disclosed to Medi-Cal. In New York and many other states, any gifts done during the look back period are aggregated, meaning they're added together, and then the total sum of the gifts is counted as the amount of money transferred. And that number is then used to determine how many months or years of ineligibility for Medi-Cal the person is going to have to pay privately for before Medi-Cal or Medicaid in other states will step in to pay for their care. We are, I believe, the only state, but maybe I'm wrong, that does not aggregate gifts. So when we make transfers of gifts, families are able to preserve a significant amount of assets, but the gifts can't be made in one big lump sum. So gifts are usually broken down and done over a period of time, pursuant to Medi-Cal's rules, and then all of that is disclosed to Medi-Cal, and as long as it's done right, it should cause no penalty and no waiting period during which people have to pay privately out of pocket. Once all the gifts are done, everything is disclosed. It takes a couple of months to get that Medi-Cal approval. And then once it's approved, the family can then apply for in-home support services if their goal is to get additional payment for caregivers at home. They will ask some questions about medicine, health, doctors, and then they will send a social worker to evaluate the patient. And based on that evaluation, they will determine how many hours a person can qualify for that Medi-Cal will pay for. Income, in addition to assets, does play a role in traditional Medi-Cal planning. Medi-Cal allows for the well spouse between the two sources of income, between husband and wife, or husband and husband, or wife and wife, or whomever the family consists of, to have a little bit over $3,000. It's like $3,260. So if the well spouse has $2,000 in income and the applicant spouse has $2,000 of income, the well spouse will get to keep about half of the ill spouse's income, and the rest will be deemed as their share of cost, which means it's like a deductible when you look at health insurance. You first have to pay $1,000 a month for caregivers at home before Medi-Cal will step in and pay for that which they have deemed you to be eligible for. The last few clients that have applied for in-home support services, and again, it's very case by case. Sometimes you get less coverage depending on your limitations. Sometimes you get more. The last few cases I've heard have gotten 150 hours a month, which is pretty significant. That's almost 40 hours a week. And then you have a list of caregivers that you can interview that they provide, who you can use as caregivers that Medi-Cal will pay for. So that is a big benefit in wanting to get additional care without having to pay for it significantly out of pocket when you want to stay in the home. If, unfortunately, and again, this is usually people's last resort, care in the home is no longer feasible and a person needs to go into a skilled nursing facility, Medi-Cal will pay 100% of that bill minus the share of cost. The share of cost is your deductible. You pay that to the facility each month, and then Medi-Cal will pay the balance of the bill. So it can be quite a significant benefit. If, however, the individuals come to my office and they don't have estate planning done, and the spouse that needs Medi-Cal does not have mental capacity, that is usually the most challenging case. You can't consent to gifting your assets to your children or your parents if you don't have capacity. And just because your spouse's name is in a joint account doesn't give that spouse the right to take your assets and give them to themselves or the parents or the children, which is why having powers of attorney in place over your finances and or trusts that authorize those transfers in my world are so significant. So oftentimes in cases where there is no estate plan, we can sometimes go to court and ask for the court to allow us to transfer all assets from the ill spouse to the well spouse, and then the well spouse can then transfer it to children or parents. But if it's a second marriage where children from both sides, or, it's not always an ideal case. So it's possible, but it's more costly, it's more timely, it's more risky. You're dealing with the court, which is not always objective. And so it's always our last resort. And you can only go to court if income numbers work with the formulas that Medi-Cal rules give for us. And I'm not going to get into the numbers because it's just going to confuse you and make it seem overwhelming. But I just want you to know that there are options if no estate planning documents are in place and we're dealing with an individual that lacks capacity, but those options are more limited and don't always apply to the situation. If the applicant, the patient who needs Medi-Cal is not married, we don't have an option to go to court. So that's why it's crucial to have an estate plan in place and have powers that authorize the transfer of assets to people that you trust. That's basically Medi-Cal and eligibility and how it intertwines with estate planning. There is another aspect that I do get a lot of questions for, and that's, okay, great, we got Medi-Cal in place, but we still have this house and we still have this 130,000 and we have some money that our kids are holding on to for our benefit. So we're okay, we didn't have to spend through everything. But what about this thing we hear about, Medi-Cal recovery? What happens? Is Medi-Cal going to come after my house because I still own it after I've passed? And as of 2017, Medi-Cal's rules have become very consumer friendly. Before, people used to have to put their house into an irrevocable trust, which essentially is much like a gift to your children of your house. Now, Medi-Cal will only seek recovery against assets that are passing through probate. So if you have a house and you don't have an estate plan, or you only have a will, yes, that house is subject to recovery after both individuals have passed. Although if the well spouse survives the ill spouse, the house is protected. Mm. But if you have a trust and that house is in a trust, it's not going to pass through probate. So that house is not subject to recovery regardless of which spouse has passed. Likewise, the $130,000, if those funds are also in a trust, they're also protected from Medi-Cal recovery because they're not going to pass through probate. Mm-hmm. Any small assets would not naturally not pass through probate, so they would also be protected from recovery. So it's easy to protect assets from recovery and not have to have a payback on death and qualify for Medi-Cal, so that some of the financial burden can be taken care of and the well spouse can still, be able to afford their life and quality of life with the assets that have been set aside and not have to spend through everything. But these are all very valid concerns, and we try to hold your hand as much as possible and save every penny that we can.
Maya, I have a question for you.
Yes.
So when I have clients who come in, particularly somebody with ALS, and they have had a diagnosis, they've already had symptoms usually for a year, and then they get diagnosed. And, this is my elementary assumption. And I talked a little bit to Lindsay about this too, but in my mind, I figure they have 2 to 4 years often before this just takes their life. So if we have such a short time frame, and their care is going to get progressively worse. So at first it's something that they can manage at home, and the kids and everybody pitch in. But as time goes on, it gets harder and harder. Is it, let's say it's this normal family, the easy family, husband, wife, adult kids, everyone's on the same page. We're not worried about people embezzling and taking advantage, all that stuff. Do you think it's still worth doing Medi-Cal planning? And we've got assets. We've got, let's say 500,000 in retirement. We've got a home that has a mortgage, but it's worth $1 million because we live here in Scripps Ranch or wherever. Right. And we have a mortgage on it. We may have investable assets of maybe another 400,000. Do you think that's worth doing Medi-Cal planning for?
I do, because getting Medi-Cal in place isn't going to take a significant amount of time. You can move hundreds of thousands of dollars over the course of a month or two. So it's not like it's going to take us a year of transferring funds before we can qualify. And as you say, as the illness progresses, they're going to need more care. So maybe you start with getting Medi-Cal in place at home and have caregivers help the spouse or the caregiver that's already in place. And as things get progressively worse, if they have to go into a facility, Medi-Cal's already in place and will take over paying for the care at the facility. 2 years, 2 to 4 years, costs can go up significantly. And so they can go through that $400,000 of investment accounts fairly quickly with caregivers costing, anywhere from 15 to 20,000 for 24-hour care at home. But I think especially that the well spouse has a long life ahead of them and will need to live off of something after, unfortunately, the ill spouse has passed. I think both of their goals would be to preserve as much as possible and take advantage of any care that's out there that they could potentially be eligible for. Time frame is not an issue on our
Okay.
end. We can move pretty quickly and get eligibility pretty quickly and preserve assets, because 2 years is a significant amount of time at paying 20K a year, a month.
Yes, it is. Well, then that leads me to cost. And just so people understand, like when you do a complete estate plan, if it's something as basic as, you can do a healthcare directive yourself and do it online. Um, and I don't think a healthcare directive impacts Medi-Cal planning. It's more the financial power of attorney. So when you have a financial power of attorney done, and for example, in our firm, when we do a financial power of attorney, we charge $350 for one, and it will have the gifting provisions and all the Medi-Cal planning provisions. If you're talking about a comprehensive estate plan with a trust and you're single, in our firm, you're going to be paying between $2,500 and $3,500 for a complete estate plan. If you're married, you're going to be paying between $3,500 and $5,000 for a complete estate plan. I know your firm also does estate planning, and maybe those fees are consistent with yours. But how then do you charge for Medi-Cal planning?
It depends on the case. Generally, it does take, it's probably a 3 to 6 month process, depending on the complexity of the case, from in analyzing assets to coming up with a gifting plan or a transfer plan to putting in additional trusts in place if need be, if we want to protect the beneficiaries from themselves, to submitting everything and then doing a very extensive explanation to Medi-Cal of everything that transpired in those months, to getting an approval. And oftentimes there's an appeal that has to be filed because the turnaround with workers for the county is pretty quick. So oftentimes they have new workers that don't know the law, and so we have to teach them the law. And so it can get complicated, but that's the challenge, and that's what we enjoy, is making sure everything is done right without burdening the clients with that. So our fee for a Medi-Cal matter is generally about $9,500, and that covers everything from A to Z. If I have a family that comes to me and it's a single person and they have 25, 30,000, so I said 130 is for the married individuals. For a single individual, I didn't mention this, the limit is one house, one car, and $2,000. So you get far less in order to qualify for Medi-Cal if you're not married, unfortunately. And so if you have a girlfriend or a boyfriend or a significant other for the past 30 years and you've never been married, or for the past 10 years, unfortunately, you are limited to that $2,000 limit before you can be qualified for Medi-Cal. If that person's assets are insignificant and they have like 20 to 30,000 and it's not a complicated case, we will reduce that fee significantly. So we'll go down to 5,000 to 7,000. And that kind of helps them bring it down to the limit as it is. But yeah, we take into consideration the extent of assets, but the general fee is $9,500.
And I know my slide, I said, when you're finding an attorney, attend a free consultation. And we offer free consultations all the time because we're just educating people on wills versus trusts. We don't give legal advice. But I would imagine when people come to you, you can't just give them general advice. Everyone has a specific set of circumstances. So do you charge for your initial consultation?
We do not. We also offer a free initial consultation. Oftentimes when a person contacts us, I don't know exactly what they're looking for. And oftentimes they don't know what they're looking for. They just know that some professional told them to contact us because this is what they need, but they don't exactly know what the plan is going to look like. And for us, usually the initial consultation is a lot of the research. It's finding out what estate planning documents do you have in place, if any? What assets are we working with? And then we can form, what's the family dynamic like? Is this a first or a second marriage? Are there family members? Do we have um, people with complications? And then we figure out, okay, this is what the plan would look like, and this is what the cost would be. So the initial consultation is really brainstorming together to figure out what are we trying to accomplish, what are our goals, and what costs are they looking at. And oftentimes people will call with follow-up clients. We, like you, are in the business to help people. That's the biggest reward in this position, is we're really counselors. We're really holding their hand and walking them through an extremely emotional and painful and stressful time. We're not charging for every call. We're not charging for follow-up questions. We're here until we figure out a plan that makes sense. So people can call, an email with follow-up questions even after the first initial consultations. We don't charge for that.
That's awesome.
Yeah. Well,
I learned a lot. Thank
I
you.
know, from both of you. Oh my gosh, I'm like absorbing it all. You guys have both just done so.
I think essentially people just need to understand that when they're in this situation, the easiest way for them to navigate this challenging time is to find a professional or two or three that they trust, and let that person guide them to take as much of the burden off of them so they could focus on their time with their loved one and preserving what they own.
Mhm. Yeah.
Amen.
Yeah. That's great kind of insight and advice just from even what you've kind of come into contact with your client. So thanks so much, Maya, for sharing. And
No,
thanks.
it's my pleasure. Thank you so much for thinking of me, Stacy. Thank you so much for including me. I think a lot of people don't know the options. A lot of people call and say, I didn't know I can't get Medi-Cal. I have too much. And people just don't realize that California has a lot of options that people can still qualify. So the more people kind of get the word out, the easier their life can be.
Mhm.
So thank you guys.
Yeah. Well, I know I do want to be kind of mindful of the time here. I know, Raphael, you joined us, and I just wanted to, throw it out to you if you have any follow-up questions for either Maya or Stacy.
His
I appreciate all the information. It's something I will be checking out with my wife. Thank you so much.
You're
Yeah.
very welcome. Thank you so much for joining us.
Yeah. Thanks, Raphael. Yeah, you're welcome to contact, us at the chapter, or I know you guys shared your contact information too. So, Raphael, you're welcome to stay in touch. Okay. And well, other than that, I mean, I guess my only question I wanted to follow up with is for both of you. If our families are watching, there's a lot of awesome information they're probably going to be absorbing. And if they're kind of thinking to themselves, especially whether it's those three documents that you were referring to, Stacy, or just with Medi-Cal, if they're kind of going, where do I start? What would you recommend? Like almost like as a first step?
Well, I think what Maya said is call one of us,
Mhm.
and I honestly think that calling Maya's office is the best because she has the answers to all of it.
Thank you, Stacy.
Our office does not do the Medi-Cal planning, and as much as I love being a resource for the ALS Foundation and helping in that, and we will always help, we're going to also flip over to Maya. So they might as well start there. And Maya, I don't think we had a slide with your information. So maybe you want to give them a phone number or something.
Yes. So the best way to reach us is 800-836-1124. And the name of the firm is Ratner and Pinchman. I'm Maya Pinchman. I didn't really go through this in the beginning. My partner is Stephen Ratner. We work on all these cases together. So again, it's 800-836-1124. And you guys can always just Google us and you'll see all of our contact information as well.
Awesome. All right.
Thank you so much.
And thank you so much. And this will be a resource, not just for here live, but for other families in the future. We love sending these links over when they have these questions pop up. So awesome, awesome job.
Thank you so much.
Yes, thank you for having us.
Yeah, thank you. Any
Have a
last
good-
thoughts or questions before we end?
No, I got all my questions answered.
I know. I was like, yeah, I have a lot to process, but
And we can always, if patients from your chapter call one of us, we can always team up and have like Stacy do the estate planning portion, and then they come over to us to do the Medi-Cal. We can kind of figure out, and then we can reduce our fees so that they're not paying, double paying. So we can figure out a system that's more manageable for everyone.
wow. Yeah, that's great. Thank you, Maya.
My pleasure.
All right, guys. Well, with that, we'll go ahead and close and we'll go from there. But thank you again.
My pleasure. Have a great day, everyone.
You
Thank
too.
Bye.
Bye.
Bye-bye.